To beat the hearsay rule, you must apply the three-part test. Before you look for saving clauses, evaluate the guest. Was it said out of court, outside this current space? Was a human making an assertion in the place? Are you offering the statement just to prove it's factually true? To prove the actual content of the words they spoke to you. If it's a clock or a radar gun, it's a machine, so let it pass. And if you're not proving the facts, it skips the hearsay class. Oh, is it hearsay? Check the three-part test. Out of court, human statement proving truth is best. But verbal acts in listeners' minds are not hearsay clear. And opposing party statements are admissible, my dear. Prior sworn inconsistencies, identifications too. Witness live on cross-exam will make it pass right through. Under Rule 801, exclusions take the stand. They are labeled non-hearsay across the MBE land. A live testifying witness with a prior statement known must be subject to cross-examination on the throne. If it's a prior inconsistent line, it needs a perjury oath, or it's only for impeachment, not substantive growth. And the opposing party's own words, they can always come right in. No personal knowledge needed. Let the vicarious wins begin. Oh, is it hearsay? Check the three-part test. Out of court, human statement proving truth is best. But verbal acts in listeners' minds are non-hearsay clear. And opposing party statements are admissible, my dear. Prior sworn inconsistencies, identifications too. Witness live on cross-exam will make it pass right through. When the declarant's missing, use your PRISM to see if they are unavailable for trial. Delivery, dying declarations only count for homicide and civil claims. They don't have to die, just be unavailable to the games. And watch the past recollection recorded trap on your test. It's read into evidence but can't be an exhibit with the rest. Unless the opponent offers it, it stays a spoken line. And business records fail if bystanders talk out of line. Oh, is it hearsay? Check the three-part test. Out of court, human statement proving truth is best. But verbal acts in listeners' minds are non-hearsay clear. And opposing party statements are admissible, my dear. Prior sworn inconsistencies, identifications too. Witness live on cross-exam will make it pass right through. But wait, in criminal cases, the confrontation clause strikes hard. If it's a testimonial statement, the defense will hold the card. If the speaker is unavailable and the cross-exam was denied, it is barred from the courtroom. Leave it cast aside. Unless a 911, an emergency is happening right then. Now you've cleared the hearsay hurdle. Go and get your 10.